Can a married daughter claim her father's property? The real truth of the law. At around 9 o'clock at night, a family meeting was going on in the courtyard of an old house. The father was no longer in this world, and property papers were kept on the table. The elder son was silently looking at the papers. The younger son was running a calculator, and the married daughter, standing near the door, was listening to everyone's conversation. After some time, someone said softly, "You are already married, how do you have a share?" This very one sentence changed the air of that house. There was a question in the daughter's eyes. Does her relationship with her father's house end after marriage? Does the law also believe this? The fear begins right here. If daughters do not know their rights, then in the name of family tradition, their legal share can silently disappear. The curiosity is whether the law of India stands with that daughter or with that old thinking in which only the son was considered the real heir of the property. Ancestral versus self-acquired property. First of all, one thing has to be understood clearly. The father's property can be of two types, ancestral property and self-acquired property. In both, the daughter's rights are seen in different ways. Ancestral property is that which has been coming down in the family line for several generations and is connected with the rules of a Hindu undivided family or co-parsonary. Self-acquired property is that which the father has bought from his own earnings or which he received through a gift, will, settlement or any personal source. This difference is not small. Many disputes start for this very reason, because the family calls every property father's property, but the law looks at its nature. The Hindu Succession Act 1956 and the 2005 amendment strengthened the rights of daughters a lot. This law gave daughters a place equal to sons. After the 2005 amendment, a daughter becomes a co-parsoner by birth in a Hindu Mitakshara co-parsonary. This means, in ancestral property her status can be just like a son's. It does not make a difference from this fact whether the daughter is married or unmarried. Marriage does not end the property right received from her birth. The law did not say that a daughter is entitled only when she lives in the father's house. The law looked at the relation, not the marital status. The Supreme Court cleared in the Vinita Sharma case that a daughter's co-parsonary right is from birth. Whether the father is alive on the 9th of September 2005 or not is not a necessary condition. But this does not mean that every old matter will open up automatically. If a partition has already taken place before the 20th of December 2004 through a valid registered partition or court decree, then the situation can be different. Right here, confusion happens in many families. An attempt is made to exclude the daughter by telling a story of an oral partition, but the law looks for valid proof. If it was just said while sitting inside the house that a partition had taken place years ago, the court does not accept that statement blindly. What happens if there is a will? Now understand the matter of self-acquired property. If the father is the owner of a property bought from his own earnings, then during his lifetime he can sell it, gift it or make a will. When the father is alive, then the daughter cannot claim an automatic share from birth on his self-acquired property. The father's wish and legal ownership matter a lot here. But if the father dies without a will, which is called intestate in the law, then his self-acquired property is divided among the legal heirs. In the case of a Hindu male, Class 1 heirs come first. This can include the daughter, son, widow, mother and the branch of some predeceased children. Therefore, if the father went without a will, then the daughter's share can be equal to the son's. But how much the share will be, will depend on the number of the remaining Class 1 heirs. If there are only one son and one daughter, and there is no widow or mother, then both can get an equal share. But if the father's wife and mother are also alive, then the daughter's share will not be half. The property will divide among all Class 1 heirs according to the rules. This is the very reason why saying the daughter will always get a half share is not correct in every case. The correct thing is, the daughter gets legal treatment equal to the son. Now the question comes, if the father made a will and did not write the daughter's name, then what will happen? Here the law becomes a little different. In Hindu law, a person can give through a will his such property which he can legally dispose of. If a share is not given to the daughter in a valid will, then the daughter's claim can become weak. But if the will is suspicious, made under pressure, forged, or the father's mental capacity was doubtful, then it can be challenged in court. A will does not mean a magic paper. It may have to pass through the tests of legal requirements, witness, intention, and genuineness. Even in ancestral property, the father cannot make a will of the entire family property if the rights of other co-parsoneers are in it. They can generally decide only on their own legal share. This very point is very important. If the father makes a will of co-parsonary property, by calling it his single property, then the daughter can demand her co-partner's share. Marriage and emotional pressure. Let us understand the matter of a married daughter again. After marriage, she went to another house, but according to the law, her legal relationship with the birth family does not end. Some families say, a lot was spent on the wedding, now property will not be given. But wedding expenses do not become an automatic substitute for a daughter's inheritance right. Dowry is illegal, and making the gifts given in a wedding a shield against the daughter's legal inheritance right is not the correct approach. If the daughter has voluntarily signed a registered release deed or relinquishment deed, then the matter can be different. But that too should be with free consent. Many times, papers are got signed from a sister under emotional pressure. If there is fraud, coercion or misrepresentation, then such documents can be challenged. People also mistake a mutation entry for ownership. In reality, mutation is for the revenue record. It is not always proof of the final title. If the mutation of the property was done only in the names of the sons, then it does not mean that the daughter's legal right is ended forever. The daughter can file a partition suit, can send a legal notice, can demand a revenue record correction, and if needed, can go to civil court. But time is very important in property disputes. Therefore, remaining silent after knowing the right can many times cause practical loss. If the father gave the property to some son during his lifetime through a registered gift deed, then the daughter cannot make a simple claim later. But if the gift happened through fraud or undue influence, there can be a way to challenge. If the property has already been sold through a valid sale deed, then the buyer's rights also matter. Therefore, no final opinion is made without seeing the chain of documents. Checkpoints for daughters. Legal heirs certificate, succession certificate, will, partition deed, gift deed, sale deed, revenue record, and family tree. All these documents can change the story. A daughter should first find out in whose name the property is. In the father's name, in the grandfather's name, in the name of the huff, or in the name of some trust/company. After this, it should be seen whether the property is ancestral or self-acquired. Without this difference, any advice will remain incomplete. Third step. Check the father's death date and the existence of a will. Because death before or after certain legal changes, and the status of the will, both can matter. Fourth step. Has any registered partition taken place before? If yes, it is necessary to see the date, document number and parties. Fifth step. Did the daughter ever release her share? If she did, was the document genuinely signed or under pressure? Now it is necessary to understand the angle of religion too. The Hindu Succession Act applies to Hindus, Buddhists, Jains, and Sikhs. The inheritance rules of Muslim, Christian, and Parsi communities can come under different personal laws or the Indian Succession Act. Therefore, the same rule does not apply to every family. This script is mainly from the angle of the Hindu Succession Act. In any specific case, a final legal advice is made only after seeing the local law, personal law, and documents. One more thing, the daughter's right is not just to take property, it is also to manage property. Being a co-partner means liabilities can also come along with rights. If there is debt, tax, litigation, or encumbrance on the ancestral property, then along with the share, the reality of responsibility will also have to be understood. Beyond emotions, documents matter. Property is always full of emotion. There are memories in a house, there is the hard work of parents, and there is the childhood story between siblings. But when it comes to the law, documentation is also needed along with emotion. Just everyone knows is not always enough in court. If a daughter demands her share, it does not mean she is breaking the family. Many times, she is only demanding that very respect which the law has already given. The real problem starts when the daughter is treated like an outsider in a family discussion. The law did not consider her an outsider. Think, in the very house where the daughter spent her childhood, in the courtyard where she learned to walk for the first time, if people become uncomfortable as soon as they hear her name in that same house, how deep the pain will be. But the work of the law is not to repeat old thinking. The work of the law is to recognize rights, even if it takes time for society to accept. Even today, many daughters do not claim just because they have a fear that brothers will become angry or the relationship with the maternal home will break. Many daughters also remain silent because they feel that after marriage no right of theirs is left. This misunderstanding is the most dangerous. The truth is that a married daughter can also be a legal heir. She can be a co-partner in ancestral property, and she can claim a share in the father's intestate property. But in every case, it is necessary to check documents, property nature, will, partition, and previous transactions. The law is strong, but facts are even more important than that. If there is a property issue in any family, a solution can be searched through conversation first. A family settlement can also be done in a legal way. But if the settlement is written, clear and properly registered, future disputes reduce. Otherwise, today's oral consent can become tomorrow's court case. If a father does clear will, nomination, property records and family communication in his life itself, many disputes between children can stop. Making a will is not loving some child less. It is a responsible way to reduce confusion. The story of the daughter standing in that same old courtyard does not end here. When she understood the law, her voice did not change, but her fear reduced. She said only this much: I do not want a fight, but I want to understand my right. Many times, change starts from this very quiet sentence. Because a daughter's right on her father's property is not a question of mercy, it is a question of law, equality and respect. And a married daughter should remember this, that marriage might have changed her home, but it did not end her legal rights connected with her birth automatically. Therefore, if talk of property is going on in your house, see documents before tradition, understand the law before emotion, and know the truth before a decision.
If this video has taught you something new, or if you feel this information should reach more people, don't forget to like and share the video. Your small share can become valuable and useful information for someone else. If you have any questions related to this topic, or if you would like to share your opinion with us, be sure to write in the comment box. We read every question and suggestion from you, because your feedback inspires us to create better content. And if you want to keep receiving such interesting and reliable information about business, the economy, and the world in the future, then don't forget to subscribe to our channel GRT Business and also press the bell icon so that you get notifications of every new video directly. At GRT Business, we always strive to provide you with accurate, balanced, and reliable information. Our news and analysis are prepared based on information obtained from various news agencies, public sources, and public opinion. We make every effort to verify and validate each fact as much as possible. But in case of any possible error or dispute, the responsibility lies with the respective sources. Our only aim is to present you with a correct and trustworthy perspective so that you can understand any topic better.